today I decided to give you a little taster session which touches upon 3 modules that you will be offered at CCLS in the next academic year. The session is called English Law and Maritime Contracts, and the contracts that we will be touching upon in this session are charter party contracts and marine insurance contracts. And we're going to see some examples of how they work, and also we're going to look at why English law is such a popular choice of law, and the English jurisdiction is such a popular choice of forum for this kind of contract. We're also going to look at arbitration agreements, maritime arbitration agreements, which also tend to choose an English seat of arbitration, which means that the arbitration takes place in England, usually in London, in accordance with English arbitration law. So we're going to touch upon all these 3 types of contracts during the session. And as I indicated earlier, you're very welcome to stop me and ask questions should you need. Now, what I'll do is, while I'm giving the presentation, I'll stop my video simply because it improves connectivity, and it means that I won't keep breaking up. So I'll do that now, but of course, as I said, even if you can't see me, you can still ask me questions, and I will still very happily respond to them. So let's start by looking at the features of maritime contracts, which make it very important to choose the right governing law and the right forum in order to ensure their enforcement and to resolve disputes that arise under the contracts or in connection with the contracts. So as I've already mentioned, the 2 types of contracts I'll be looking at are contracts for the use of a vessel, that is charter party contracts. This is the name by which they're known. Essentially, a charter party contract is a contract to rent a ship. You can rent a ship for a period of time, in which case you are paying what is called hire, usually on a monthly basis. Or you can charter a ship for a particular voyage. So you pay a flat fee, which is called the freight, and that freight will cover the entire voyage, including a set amount of time for loading goods and for unloading goods. So all of that is covered by one flat fee called the freight. But essentially, in every charter party, what you're doing is you're renting a vessel. We'll also look at contracts for insuring ship or cargo. That is marine insurance contracts. Now, if you attended the introduction session I gave last week, you will remember that I did talk there about how risky shipping is, how many perils are faced while the voyage is being undertaken. And the perils aren't just faced by the ship, they are also faced by the cargo. So you have different types of insurance for the maritime field. You have the ones that I'll be focusing on for this session is hull and machinery insurance, that is insurance for the ship itself. A ship is a very, very expensive piece of equipment. And contracts for insuring the cargo. Both of these are known collectively as marine insurance contracts. Now, marine insurance law, modern marine insurance law, originated in England, and the English maritime law is very, very influential across the world, particularly the common law world. But marine insurance law continues to evolve. It continues to be reformed in response to the times. So we'll see again why English law is such a popular choice of law for marine insurance contracts. Now, in the bullet points on this slide, I have listed some features of these types of contracts. First of all, the performance, the contract features the performance of contractual obligations. That's the charter party contract, where the ship owner agrees to perform certain contractual obligations towards the charterer, the person renting the ship. Marine insurance contracts involve risks, the transfer of risks between the insurer and the assured. So from the assured to the insurer. Now, both of these elements, these terms, they transcend national boundaries because the goods and the vessel are moving between jurisdictions. So that's one feature of maritime contracts. They are transnational in nature. They are not limited to performance in one jurisdiction. Contractual terms need to provide for complex factual situations because the ship is going from somewhere to somewhere else. And of course, the two places are different. It's crossing the sea in the meantime, so it's facing many, many difficult conditions, potentially. It may come into contact with other vessels. And the factual circumstances in which the contract is being performed are very, very complex. Another thing to note about these contracts is that they are often agreed, they are negotiated and agreed by non-lawyers. Very often they are agreed by intermediaries, representatives for the parties, known as brokers. So that's another very important thing to remember. These people who are negotiating these contracts and agreeing terms do not have legal training. When disputes arise, contracts have to be interpreted and enforced. So English law becomes very important at this particular point in time when disputes arise, because that is when you have to interpret the contract and that is where you have to enforce it. And the English law and forum are frequently chosen. This presentation is going to be about why. Why do we choose, why does the maritime industry choose English law so often for its contracts? So these are the main reasons for the choice. First of all, English law principles and rules of contractual construction. Construction there means interpretation, to construe the contract. These principles and rules favor commercially sensitive interpretations of maritime contracts. That is, they are not interpreting the contract in a vacuum, focusing merely on the words. They interpret the contract in its commercial context. That is, they take into account what the words would mean within this commercial context, what they would mean to business parties operating in this arena, in this market. Second, the approach to consequences of breach of contract balances certainty and fairness. So essentially, you can rest assured if your dispute is going to the English courts, that if it turns out you've breached the contract, then the consequences are going to achieve a balance between providing certainty to the person who suffered the breach and being proportionate towards the person who breached. So you have that balance there, which is highly valued. Thirdly, a system of precedent provides a high level of certainty and predictability. In other words, you know that if the contract, if these words, if these standard terms were interpreted in this way today, they will be interpreted in the same way tomorrow, because you have a system of precedent. That is, future courts are bound by the decisions of prior courts, past decisions. Finally, there is the availability in the English jurisdiction of cost-effective and comparatively efficient dispute resolution procedures. And this is very important because very often the parties want people who understand the context deciding their disputes. They want people with expertise in the particular field. And we're going to see how that is provided within an English forum. Now, these are the rules of interpretation. I'm going to take each one of these reasons in turn, and I'm going to start with the first one, which is principles and rules of contractual construction. Now, these were laid out by Lord Hoffman. Now, Lord Hoffman is a professor at CCLS. He retired from the House of Lords, as it then was. It's now the Supreme Court. He retired from the House of Lords about 10 years ago, and since then he has joined CCLS as a professor. And in a 1997 case decided by the House of Lords called Investors' Compensation Scheme and West Bromwich Building Society, Lord Hoffman set out the principles of interpretation. He basically summarized them into 5 principles. And as you can see, if you look through these principles, there's a very big focus on context, because what you're doing when you're interpreting the contract is you are ascertaining meaning, but you are not establishing what meaning was attributed to the words by the particular parties, by the actual parties to the contract. You are ascertaining what the words would have meant to a reasonable person, observing the communications that took place between the parties. Now, this reasonable person is going to be someone who has all the same background knowledge which the parties would have had in that situation, or would reasonably have been available to them in that situation. So it's not just a random man in the street, it's actually someone who is embedded in the context. How would that person have understood the meaning of the words? Now, what do we mean by background? This is explained in principle number 2. The background includes absolutely anything which would have affected the way in which the language of the document would have been understood by this reasonable person. So it's essentially a flexible notion, and it allows the dispute resolver, the person interpreting the contract, to take into account everything that is relevant, everything which would have been relevant to a reasonable person within that context. However, you don't take into account previous negotiations and declarations of subjective intent, because determining the meaning of the contract is an exercise in objectivity. You have to take an objective approach. And then the final 2 principles are on this slide. Again, you take reasonableness as a basic standard in interpreting the meaning of the words used in the contract. And finally, and this is principle 5, which we're going to look at in a bit more detail, you make sure that the interpretation you have adopted makes sense. So you are not bound by what would have been linguistic mistakes. the law does not require judges to attribute to the parties an intention which they plainly, that is, evidently, obviously, could not have had. So the interpretation you come up with needs to be in line with common sense. And this was again highlighted in Arnold and Britton. Now, by this point, 2015, the House of Lords had become the Supreme Court. It was no longer the House of Lords. But it was made up of what we still call the Law Lords. And it is still the highest court of the land. Now, what the court did in Arnold and Britton was they actually re-summarized the principles of interpretation of contracts. And they emphasized once more the meaning of the relevant words in their documentary, factual, and commercial context. So again, they emphasized the importance of context. And if you look at the summary of those 6 elements to interpretation, you will see that number 5 is commercial common sense. You need to take into account what would make sense commercially. So these are the principles of interpretation. And in light of those principles, it is very advantageous for commercial parties to make English law the governing law of their contract, because what it means is that they won't end up with nonsensical results. Whatever interpretation is adopted will actually have some commercial logic behind it. And this is taken from a 1984 case, the Antaios. Now you'll notice that this case, unlike the first 2 which I talked about, so the first 2 had the usual format, which is Investors' Compensation Scheme and West Bromwich Building Society. So claimant versus defendant. It's the name of the claimant, the case between the claimant and the defendant. But you see that this case here has a different name, the Antaios. Now, the Antaios is the name of the vessel. Okay, and this is basically a traditional, a customary way of referring to shipping cases by the name of the vessel. So this makes it easier for students because you don't have to remember the names of the claimant and the defendant. You just have to remember the name of the ship. Now, this is what was held in the Antaios, a 1984 case, and I think it summarizes the principle very well. If detailed semantic and syntactical, that is grammatical, analysis of a word in a commercial contract is going to lead to a conclusion that flouts business common sense, it must be made to yield to business common sense. Now, what this does, all of this, is it raises the question, what is business common sense? And this question has given rise to some debate. Now, this is another case, this time from 2013. You will notice when you look at the name of a case, and this is quite important, and it's a good thing to be aware of from the start, from the very beginning of your shipping law degree, shipping law studies. You'll see that you have the name of the claimant, followed by the name of the defendant. And then you have the year where the case was decided, or where the case was reported, the court decision was reported. Then you have here EWCA, That stands for England and Wales Court of Appeal, Civil Division, CIV. Then you have the page in the reports where the report of the decision commences. That's page 416. So there were many cases before this in 2013, because it doesn't start until page 416 of the reports. And then in square brackets here, you have the paragraph number. That is the paragraph I am quoting here in this slide. So this content comes from this paragraph of the decision, paragraph 24. You will see that in this case here, Arnold and Britain, it was 2015, and then UK, United Kingdom Supreme Court, page 36. So this was early in 2015. It might have been the second case decided by the Supreme Court in 2015. Now this says United Kingdom, but you'll see that this says England and Wales. What you need to remember is that there's more than one jurisdiction in the United Kingdom. England and Wales is one jurisdiction. Scotland is a separate jurisdiction. Northern Ireland is a separate jurisdiction. So there are 3 jurisdictions in all. Now, each jurisdiction has its own High Court and Court of Appeal, but the Supreme Court is the Supreme Court for all the jurisdictions. This is why this says United Kingdom Supreme Court. Okay, so that was a little parenthesis about what is known as the neutral citation. The neutral citation is because it is run by the Ministry of Justice. This citation is Lloyd's reports. It's not a neutral citation. It's a private collection of court decisions. So this is essentially, this case was decided before the neutral citations came in. The neutral citations came in 2001. Okay, so now you know that this is a decision of the Court of Appeal. BMA was the appellant, African Minerals Finance was the respondent. And this is what the court held in BMA. This is about commercial common sense. And it's a clarification about how the court uses this principle of commercial common sense. And this case was decided by another professor, a visiting professor at CCLS, Sir Richard Akins. He used to be a judge in the Court of Appeal. He is now retired. And this is what he decided. First, commercial common sense is not to be elevated to an overriding criterion of construction. And secondly, the parties should not be subjected to the individual judge's own notions of what might have been the sensible solution to the parties' conundrum. I would add, still less should the issue of construction be determined by what seems like commercial common sense from the point of view of one of the parties to the contract. So what this is saying is that, first of all, commercial common sense must be used together with all the other principles. You'll see all the other principles that are listed here. Okay, there are 6 principles, not just one. Secondly, the other point that is being made here is that when you're looking at business common sense or commercial common sense, you need to maintain objectivity. You have to look at it from the perspective of what is objectively common sense, from the point of view of the transaction as a whole, not from the point of view of one of the parties. And in 2016, Bernard Eder gave a lecture, a public lecture. Bernard Eder used to be a High Court judge in England. He is now an arbitrator in Singapore. And he said this in 2016, the difficulty is that a judge is often faced with competing arguments by both parties that their own particular construction is the one which best accords with business common sense, and that the other party's suggested construction is commercially unreasonable. And I am doubtful that the judge, even a commercial judge, is very well equipped properly to weigh these competing arguments. Now, this is what Bernardida said in 2016 about the problem for judges in determining what makes commercial common sense. However, bear in mind, as we shall see later on in this lecture, that most shipping disputes are decided not by courts, but by maritime arbitrators. And I'm going to come back to this point about commercial common sense and determining what makes commercial common sense when I talk about maritime arbitration later on. Because as we shall see, a lot of maritime arbitrators are drawn not from the judiciary or from the legal profession, but from the industry itself, even though they would have some legal training and some legal knowledge. Now, this is a little exercise. I don't know whether you'll be interested in undertaking it, but I've put it in just so you can have a go at deciding what makes commercial common sense. This is a case decided in 1998. And it involved a cargo insurance contract. The contract was to cover canned vegetables produced in China, which were going to be shipped to the European mainland. The cans were going to be transported in cartons from various canning plants in mainland China to the port of Shenzhen. At Shenzhen, the cartons were put into containers and they were taken to Hong Kong and put on board ocean vessels. Now, the insurance contract contained two terms which we are interested in. It contained many, many terms, but these are the two terms we are interested in. The insurance was from Shenzhen, China to Hamburg. It was placed before the containers were put on board the ocean vessel. But the cover was expressed to include ex-factory in People's Republic of China to warehouse Hamburg. Okay, now, placing insurance, just as a little side note here, placing insurance means entering into an insurance contract. So the contract was entered into before the containers were put on board. So you'll see that the contract was entered into at the third bullet point in this slide. That's the stage where the contract was entered into. But it had a term within it that said ex-factory in People's Republic of China to warehouse Hamburg. The cans suffered damage in transit between the canning plants and Shenzhen. So during the second bullet point. Now, can you tell me whether this damage was covered by the insurance? You'll see that this is insurance, marine insurance on a voyage basis. It's covering the voyage of the goods. Now, you have two terms within the contract that are somewhat contradictory. Okay, you have one term referring to Shenzhen as the starting point, and then you have another term referring to the factory in the People's Republic of China as the starting point. So what do you think makes commercial sense here? Is anyone brave enough to attempt a reply? I can see that there are two chat contributions, but nobody's attempted an answer. So would anyone like to have a go? Well, I've popped it up on here anyway. This is what the court said. The court said the use of the word factory in contradistinction to warehouse and the reference to People's Republic of China in contrast to Shenzhen were significant. They demonstrated that the provision was directed to the place where the goods were produced, that is, the canning plant itself, rather than the place where they were repacked or even in some cases relabeled. Furthermore, the insurers must be taken to know that those factories were or might be some considerable distance from Shenzhen, and accordingly the ex-factory term was construed as intending to insure the goods right from the factories to warehouse Hamburg. So the court went with the interpretation that said that the goods were covered for the entire voyage. And bear in mind that this is quite customary in cargo insurance, that you insure the goods from warehouse to warehouse. Right, so as I said earlier, the reason why you often have these seeming contradictions within the contract is that the contracts are prepared by non-lawyers. And these people just want to get the deal done because very often they are brokers, and brokers are paid a commission every time they negotiate a deal. So if they get the deal done, they get the commission. If they don't get the deal done, they don't get a commission. So they are not scrutinizing the words for consistency and clarity. They simply want to do the deal. They simply want to conclude the contract. But what it means is that there's often quite a lot of work for lawyers after the contract has already been agreed to sort out what it means. Now let's move on to consequences of breach. This was the third principle, the third feature of maritime contracts that I said at the start of this webinar that I would talk to you about. And this is another reason why English law is so often the law of choice for maritime parties. How does English law approach a breach of contract? Well, in charter parties and contracts of carriage, a repudiatory or renunciatory breach by one party gives rise to a right to terminate. So the other party becomes entitled to walk away from the contract without consequences if their counterparty commits what we call a repudiatory or renunciatory breach. That is, a breach so serious that they are deemed to have repudiated the contract. That is, given up the contract. So when that happens, you, the other party to the contract, are not obliged to carry on with performance and then simply claim damages. You are entitled to refuse to perform your own part of the bargain. So in a charter party agreement, for example, the question arises, if you are the charterer and I am the ship owner, and you fail to pay me the hire on time, okay, remember I said at the start that if you and I enter into a time charter party, whereby I rent you my ship for a period of time, you are paying me hire for the ship on a monthly basis. And we've agreed the day of the month when you're supposed to pay. Now, let's say that day comes and you don't pay me. If this is a repudiatory or renunciatory breach of contract, I can walk away. Not only can I walk away, but if there are, say, 6 months left of the charter party, and I manage to rent my ship to someone else, but at a lower hire, at a lower price, then if your failure to pay me was a repudiatory breach, I can also claim damages from you for the difference between what you would have paid me had we carried on with the charter party and what I am getting from the other person I rented to because you breached. Okay, so bear in mind there are 3 types of repudiatory breach. The first is called anticipatory breach. That is, before the day to pay hire comes, you say to me, I'm no longer going to charter your ship. I'm not paying you any money. I'm walking away from this contract. Okay, that's an anticipatory breach. I don't have to wait until the day the hire becomes due in order to sue you for damages, because you've already breached in a repudiatory or renunciatory way. Second is if at the time of performance you breach a condition. So what I would be asking myself or asking my lawyer is the term of the contract, which states you have to pay hire on a certain day, is that a condition of the contract? Because if it's a condition, it's an essential term. And even if you're 1 minute late, then I have the right to walk away, rent my ship to someone else, and sue you for damages. Finally, a sufficiently serious breach of an innominate term is also considered repudiatory, but it has to be sufficiently serious. So an innominate term is one where you can only tell whether its breach is repudiatory after it's been breached, if the breach is sufficiently serious. That is, if the consequences of the breach are sufficiently serious for the person suffering the breach. So, if a term is classified as a condition, you have certainty. You know what's going to happen if it's breached. You know in advance. On the other hand, if a term is classified as innominate, you don't have certainty. But there is a better chance that the consequences of breach will be proportionate. That is, they will be proportionate to the seriousness of the breach. Now, I'm going to give you an example of this in a little bit. For the moment, let's look at marine insurance contracts, because for insurance contracts, the law is slightly different. So, marine insurance contract terms were known by different names. So, instead of calling it a condition for a marine insurance contract, the essential term was called a warranty. Now, if you breach the warranty in a marine insurance contract, the contract automatically came to an end, no matter how trivial the breach was. So, for example, if your insurance contract said that you had to keep your fire alarm in good working condition at all times and provide regular maintenance, if you missed a maintenance appointment, even if your fire alarm was still functioning, and even if your ship was lost due to a great big storm, rather than anything to do with fire, you had breached a warranty by not providing regular maintenance, and your cover automatically came to an end as soon as you missed that maintenance appointment. And this is extremely disproportionate, and is a terrible burden for the assured. So in 2015, the Insurance Act was adopted in the UK, reforming the law to make it fairer to the assured, so that if a warranty was breached, but the risk that caused the loss had nothing to do with the warranty, then you still could recover from your insurer. And a breach of warranty no longer brought cover automatically to an end. It simply suspended cover until you remedied the breach of warranty. So we're going to look at those two different consequences of breach in turn. We're going to first look at charter parties, then we're going to look at marine insurance contracts and look at the state of the law. Now, the first thing you need to remember is that many breaches of charter party contracts, particularly time charter party contracts, are economically driven. Now, if you attended the introduction session last week, you will remember that I showed you two graphs, and one of the graphs was the Baltic Dry Bulk Index. Now, this is a similar index which shows time charter rates. Okay, so the rates of hire. And I've chosen this particular period on purpose. I chose the period from 2006 to 2009. And you will see that over these 4 years, time charter rates were incredibly volatile. So between 2006 and the middle of 2007, the rates rose exponentially. So that graph, the slope is extremely steep. It's going up very, very fast until essentially what you were looking at was over $150,000 per day to hire a Cape-size vessel. Okay? Cape-size vessel would cost you upwards of $150 a day to rent. Now, you will see that between 2008 and 2009, the rates fell, so that when it came to early 2009, you were only paying $20,000 per day to hire a Cape-size vessel. It's an incredible fall within a very, very short period of time, a few months. Now, let's say you entered into say a 2-year time charter party in 2008. Okay, you entered into a time charter party in 2008. You agreed to pay the owner $160,000 per day. In February 2009, this has already fallen. It has already fallen dramatically. And you're in a situation where you're paying $160,000 a day for a ship that you could rent today, you could charter today for $20,000 a day. Well, what you're going to try and do is get out of that contract. You have got to get out of that contract because you can't possibly afford to pay $160,000 a day for a ship that you cannot use because the financial crisis has happened and nobody's buying your goods. Nobody's selling goods, nobody's buying goods. So you have no cargo. You have no cargo to put on board the ship. And even if you did, the price of your cargo has fallen so much that it's not worth shipping it. So you're going to try and get out of that contract because you don't want to pay the ship owner $160,000 a day for a ship you are not using. And even if you needed it, you could get the same ship now for $20,000 a day. So this is what drives a number of breaches, the idea that charter rates are very, very volatile. Now, these are the container ship rates for the same period. Okay, again, you can see a lot of volatility. So it wasn't just the bulk ships that were experiencing this. It was also container ships. So let's look at how the courts treat the kind of breach where you are supposed to be paying this amount of hire on this particular day and you fail to do so. Well, in Spa Shipping, a 2016 case, the Court of Appeal clarified once and for all that the timely payment of hire clause in what is known as the New York Produce Exchange Charter Party. This is a standard form charter party which is used very, very widely in the shipping industry. It's a standard form contract for the charter of a bulk vessel, a dry bulk vessel. So dry bulk would be things like grains and farm produce that are shipped in bulk. Well, this charter party contract, the standard contract, contains a timely payment of hire clause. And the court has never actually made a decision on whether this clause is a condition of the contract or an innominate term. And finally, in 2016, this question went to the Court of Appeal, and the court decided that it is actually an innominate term. Because the reason the court decided it was an innominate term is because when you fail to pay hire on time, on the day agreed, the consequences can be either very serious for the ship owner or very trivial. If you are a day late, it's not the same as being 20 days late. It's not the same as if you were refusing to pay at all. And it's not the same as if you were insisting on a discount. So essentially, the court said the proper way to deal with a breach of this kind is to look at the consequences of the breach. That is, to look at whether what happened afterwards is very serious or very trivial. If it's very serious, the ship owner is allowed to walk away, rent her ship to someone else, and claim damages, but not otherwise. Okay, now this is the 2015 version of the New York Produce Exchange Standard Form Charter Party. And you will see that essentially, even though the court said, for the purposes of achieving justice, we need to treat this as an innominate term, the industry wants certainty. So the industry created a new clause, clause 11, which made it clear what was trivial and what was serious. So if you look at paragraph B of the clause, it tells you what is considered trivial. So if you're anything up to 3 banking days late, then that is trivial. But if you're more than 3 banking days late, then you are considered to be in serious breach of the clause, serious breach of the term of the contract. And you'll see from paragraph C that the vessel owner isn't entitled just to withdraw the vessel, but is also entitled to damages. So the court said we need to balance what is trivial with what is serious. That is, we have to balance certainty and justice. But the industry is saying we need more certainty than that. So we're actually specifying what is trivial and specifying what is serious. Everything else, which doesn't fall within paragraph B, is serious. And we want damages. The ship owner wants damages. Okay. Moving on to marine insurance law, I can see that there aren't any questions, so I'm going to keep going. But if you want to ask anything, if anything's not clear, you can always stop and ask me. So let's look at marine insurance law. Unlike the case for charter parties, we do have written law. We have one of Sir Mackenzie Chalmers's codes of commercial law covering marine insurance, and that's the Marine Insurance Act 1906. Now, this was amended in 2015, as I mentioned earlier. I've put on this slide both the old version of the provision on warranties and the reforms, the amendments following 2015. Because in 2015, what happened was the second sentence was removed. It was repealed. So section 33, paragraph 3 provided a warranty is a condition which must be exactly complied with, whether it be material to the risk or not. Okay, so whether the risk you are claiming for is perils of the seas, okay, my ship was lost in a storm. If you failed to comply with a warranty that you would keep the fire alarm in good maintenance, it doesn't matter that the risk has nothing to do with fire. You need to comply with exactly. And then this is what the second sentence provided. It provided what were the consequences of not complying with the warranty. If it be not so complied with, then subject to any express provision in the policy, the insurer is discharged from liability as from the date of the breach of warranty, but without prejudice to any liability incurred by him before that date. So as you can see, it was very draconian. No matter how tiny the breach, how trivial the breach, you lost your insurance cover. Not only that, you still had to pay the premium. Now, section 34 provided this. Non-compliance with a warranty is excused when, by reason of a change of circumstances, the warranty ceases to be applicable, or when compliance with it is rendered unlawful by any subsequent law. Okay, now that has remained. You can still have that excuse for non-compliance with a warranty. But paragraph 2 provided, where a warranty is broken, the assured cannot avail himself of the defense that the breach has been remedied and the warranty complied with before the loss. Now that has also gone, because essentially this is exactly the change that 2015 brought in. What the 2015 Act has brought in is that if you remedy the breach of warranty, if you fix, for example, the problem by maintaining or sending someone to do maintenance of your fire alarm, even if you do it late, you have remedied the breach and you are back on cover. So cover is merely suspended for the period of time for which you were late with doing the maintenance. Now, even before 2015, the courts were trying to get around the problem of the draconian effects of breach of warranties simply by saying this is not a warranty, that is, it's not an essential term of the contract, it's merely a suspensive condition. However, the Law Commission said what this does is it creates unpredictability, because it's very hard for the industry to be able to tell when the court is going to say this is a warranty and when the court is going to say, no, this is not actually a warranty, even though you called it a warranty, it's just a suspensive condition. So the Law Commission proposed the amendments that were eventually adopted in 2015, and this is what the amendment provides. As you can see, what the amendment does is it turns a warranty into a suspensive condition. That is, a term of the contract which, if it is breached, insurance cover is suspended, that is, the insurer is not liable to pay out until that breach is remedied, until what the assured promised to do, for example, maintain my fire alarm, do regular maintenance of my fire alarm, until what the assured has promised to do is done. So this is what Section 10 of the Insurance Act 2015 brought in. It brought in a balance. It brought in a balance between certainty and proportionality. Now, let's look at the importance of precedent, because this is another feature of English law which is highly prized. Now, I know I'm running out of time a little bit here, but if you are willing to carry on, we can certainly do so for another 5-10 minutes. And do please post questions if you have any. They don't need to be questions about my presentation. They can be questions about the content of the program and what you would be studying at CCLS. Now, this is the system of precedent for the English courts. So the Supreme Court binds all lower courts. The Court of Appeal binds all lower courts and itself in civil cases. And the High Court is not bound by its own decisions, but they have strong persuasive authority. So in other words, if the Court of Appeal takes a decision about how a contract should be interpreted, this is binding on all future High Court cases on the same topic, on the same issue. And it's also binding on all future Court of Appeal cases on the same issue. The only one it doesn't bind is the Supreme Court. And when the Supreme Court takes a decision, this binds all lower courts. So in other words, the industry has the certainty that this is the way this contractual term is going to be interpreted going forward, which is very, very important because a lot of maritime contracts use standard terms, that is wording that is recycled and reused over and over and over and over again for hundreds and thousands of contracts. So it's very important to have certainty as to how it's going to be understood in legal terms. So if you want to look at some standard terms, you can look at these websites. BIMCO provides a lot of standard terms, including the New York Produce Exchange Time Charter, which I've been talking about. And the International Underwriting Association provides a lot of standard terms for marine insurance. And we'll be looking at some of these contracts in quite a lot of depth in the Charter Party module and in the Marine Insurance module, respectively. So it's very interesting to look at the standard terms which the industry itself has adopted. So the final bit of my presentation is about dispute resolution, and I've already flagged up earlier two things. First of all, that a lot of disputes, international disputes, some of them have nothing to do with England or the UK at all. It might be a contract between a Greek ship owner and a French charterer to send goods, to send cargo from Southeast Asia to Africa. Okay, absolutely no connection with the UK at all, but the choice of law is English law, and the dispute resolution method chosen is London maritime arbitration. So a lot of cases, about 90% of maritime disputes go to London. 80% of maritime disputes go to London, a very huge proportion. Now, a lot of them adopt the London Maritime Arbitrators Association terms. Okay, so this is a set of rules in accordance with which the arbitration is conducted. The procedure, the arbitral procedure, follows these rules. So what does the LMAA do? It maintains a list of members who are highly qualified maritime arbitrators. And this is very important. Not only have they got a long experience as arbitrators, they've done it many, many times. They are very used to the process. They are very used to deciding cases in an efficient and effective manner. But they also, if you look at their CVs, they are all online. They also have experience in the maritime industry. So they have an understanding of how the maritime world works. And not just legal experience. We are talking about experience embedded in the industry, looking at incidents, entering into contracts, dealing with difficulties, troubleshooting. So some of them are, for example, master mariners. They are ex-master mariners. They were captains on board ships. Some of them are naval architects. Some of them are maritime engineers. Some of them worked for P&I clubs. Some of them are ship managers, or were ship managers rather. So there's a very wide range of skills and knowledge and understanding among them. As I've already said, the LMAA also drafts and adopts standards which may be modified by agreement. That is, these are standard rules in accordance with which the arbitration takes place. It doesn't involve itself in the arbitration itself. The arbitration is managed by the arbitrators, not by the LMAA. Now, something which is of value to the parties to maritime contracts is that they get to appoint the first two members of the panel. So the claimant chooses an arbitrator, the defendant chooses an arbitrator, and then those two arbitrators will appoint a third arbitrator. The arbitrators themselves determine their fees. So these are not set by the institution, and you don't have to pay anything at all to the institution. You simply pay the arbitrators for their time. And the arbitrators deliver or publish the award directly to the parties. They don't send it to the institution. The award remains completely confidential unless the parties agree to publicize it. Initiation of arbitration is by notice. Okay, so I simply send you a notice, for example, by email, asking you to appoint your arbitrator and informing you that I have appointed my arbitrator. and that commences the arbitration. So it's very it's very sort of simple and accessible as a procedure. It's cheap, and it doesn't require the formalities that are required to start a case in court. Having said that, you do normally have a lawyer. It's very common to have a lawyer. You don't need to have a lawyer, but most parties will usually have a lawyer. To keep it cheap, you can decide to arbitrate by documents only. That is, not have a hearing, because the hearing where witnesses come in and are questioned by the lawyers and by the court, by the tribunal, that's the most expensive part of an arbitration. A decision is taken by a majority. Very often decisions are unanimous, so it's quite rare to have a dissenting award. Costs can be awarded. This is up to the discretion of the arbitrators. And there are no mandatory evidentiary rules. That is, there's a lot of flexibility. The arbitrators can manage the case as they think fit. As I said, and this is the most important point, the panel often features industry experts. And finally, which is important when you think about how useful it is to have precedents sometimes, there is the possibility of appeal to the English courts, and this is unique to English arbitration. Most jurisdictions do not have the possibility of the appeal. In most jurisdictions, the finality of arbitration, of the arbitral award, is absolute. But English law provides a pathway to getting a point of law to court, because it's very important for the maritime industry to have predictability. And if you look at paragraph C of subsection 3, so this paragraph over here, you will see that it's only certain types of disputes that can go to appeal. This is the exception, not the rule. And particularly important to the maritime industry is subparagraph 2. The question of law, which you want to appeal on, which you want to go to court on from arbitration, is one of general public importance, and the decision of the tribunal is at least open to serious doubt. Okay? So, very important. And if you have a standard term, for example, the charter party term I talked to you about earlier, which says that you must pay hire on time, okay, that term of the contract, that appears in many, many thousands of charter parties because it's a standard term. So it's a question of general public importance, how it should be classified, how it should be interpreted. And in fact, the spar shipping case, which we looked at earlier, that went to the courts on a Section 69 appeal from an arbitration award. Okay, that is all I had for you. I will stop sharing my screen now. And I will put my camera on so you can see me. And yes, I'd very much like to hear any questions you may have. As I said, it doesn't have to be about English law and maritime contracts. It can be about the program more generally. I have kept you for 15 minutes longer than planned. So if there aren't any questions, I will bring the session to an end. But do feel free, if you think of anything, you can send me an email. I'm going to type in my email address now in the chat box, so you've definitely all got it. Yes, if unless there's anything you want to ask me, I will say goodbye. Okay, so is it okay if I ask you one question? How many of you are thinking of starting in September, and how many in January? Oh, good. So 2 of you starting in September, and 3 of you actually. Very, very good. Well, I'm very pleased because it's quite a nice time to start your studies. We're looking at various activities in September, and we'll definitely have the option to do them either face-to-face, or if we can't do them face-to-face, we'll do them like this, and we'll find a way of making sure you're all able to see each other and interact and, you know, just make friends. And eventually, we do hope to go to face-to-face at some point. So yes, we're very much looking forward to welcoming you in London. So I can see a hand up. Paramjot, am I saying your name correctly? You're allowed to talk if you'd like. You can unmute yourself.
Right. Yes, that's correct.
Okay, welcome. Do let us know your question.
No, I heard your question. It's just that I'm also thinking to start in September.
Oh, fantastic. Well, that's good. It will be nice because you know, you'll build up a very nice community over the year, and we're planning a really good program for you. So yes, I think you'll enjoy it. Did the lecture go okay? I'm never sure whether my voice is breaking up when I'm sharing the screen.
Well, the lecture was perfect. We could hear you very well.
Okay, good. Well, that was the feedback we got. Sorry, yes, carry on, yes.
Are the modules what are going to be available for the September intake? Are they updated on the website?
I'm not sure. If you send me the link you're looking at, I can tell you whether it's up to date or not. So just send me the link that you're looking at, and I'll respond. It's probably best to do it by email. I've popped my email address on the chat. So if you just send an email,
I got that.
Okay. So if you just send an email to that address and send me the link you're looking at, I will confirm whether it's up to date or not.
Sure, I'll do that. I'll pop an email to you, and I'll have a few questions in that. So just pertaining to the modules and the structure across 3 semesters.
Perfect. Yes, I should be able to answer all of those. So if you send me an email, I'll look at what you're looking at and I'll confirm whether it's up to date.
Splendid. So I'll send it across sometime today.
Perfect. Perfect.
You can reply at your convenience.
For sure. You'll certainly hear back from me.
Sure. Thanks a lot.
Okay. So does any of you have any experience with shipping law already, or are you all complete newbies to the field? We normally have a mixture of students every year. Some of them have already worked either in the maritime industry or done legal training with a maritime element. And some of them are fresh from their undergraduate studies and they've never had any contact with the field at all. So it's quite nice to know whether it's going to be the same this year.
Hmm?
So MMOK is new. Paramjot, are you new to it, or do you already have some previous contact with the field?
I'm actually I have been associated with the maritime field for the last 30 years.
30, my goodness. 30.
Yes, I initially I was a master mariner. Then I did a MSc in maritime operations from Liverpool.
Oh,
Uh,
brilliant. So we'll get a lot of insights from you. It's very nice when we have students with maritime experience. It does happen every year. And
then I've been working
they bring a lot to the table.
yes, then I was working in Hong Kong as a senior VP operations for a large chartering firm.
Right, so you have a very broad-based experience.
Yes, yes.
Oh, Vanessa's completed the ICS professional program in Greece. That's great. We have a very good relationship with the Hellenic Management Center that runs that program. And in fact, they hosted us. They hosted our program for a number of years.
Yes, that's a brilliant program. I've qualified for the ICS about 10 years back. I'm a fellow of the institute now. I think for the last 4 or 5 years.
Fantastic. Fantastic. Well, that's great.
Actually, I had the opportunity to attend the maritime short law course, which the International Maritime University in University of Southampton conducts. So I attended that 3-week course in 2010 in
Oh,
Southampton.
great. So you've already got some legal background as well.
Well, not a degree as such. I attended that course.
But you have a little bit of legal knowledge which you acquired in that course.
Yes, and of course that had a lot of weightage. And then when I did my MSc, one of the modules was maritime law, which had a examination at the end of it. So,
well, that's
marine
great.
insurance and maritime law were two separate modules.
That's great. Okay, so that's going to give you a very good sort of foundation for what we will be covering. Excellent. Okay, well, everybody, it was lovely to meet you.
I was seeing the website. They're saying there's an accelerated 9-month program also starting in January.
Yes, so this was very recently approved by the college. There is the option of starting in January and either doing your LLM in 9 months or doing it over 12 months, starting January, finishing December. Now, if you opt to start in January and you go for the 9-month option, that's very, very intensive. But we're just making it available for students who cannot start in September, but still want to finish by September. So for those students who cannot start before January, but still need to finish by September, it's a one-off. It's simply because of the restrictions that COVID-19 is making necessary in some countries.
Okay, understood. That makes sense. But I understand it would be very intense because
it's very intense, yes. And normally a master's is spread out over a year because it's very demanding. But just for this year, we're making that option available to be flexible and to give students what they might need in order to adapt to the times.
wonderful. But personally speaking, I think it's recommended to do the September start and go over the full year.
Well, it's always nice to do it that way. I mean, that's the way students traditionally do it. They do it from September to the end of August.
Right.
We did have to switch to online delivery for the last 3 months, for the last 3 weeks of semester 2 this year. So we taught for most of March, we taught online. And the students gave us very positive feedback. So they, instead of doing face-to-face teaching, they basically had the lectures as I've just done this one with you. For most of them, it was a really positive experience. Some of them had a little bit of difficulty with their internet connection, but everything was recorded, so they were able to access what they missed afterwards. And, you know, the feedback they gave us was great, because we also supplemented it with more material online, and we gave them tasks that they could do in their own time. And overall, it went down as a very, very positive experience. So even though there is a chance that for the first semester we cannot go face-to-face, or we can, there's a limit to the amount of time we can teach you face-to-face. Don't be afraid of the online experience, because, as I said, the feedback we've had so far has tended to be positive. It's still possible to have a really great experience. And if you'd like to speak to any of our alumni, just let me know, send me an email, let me know, and I will ask their permission and send you their contact details so you can get in touch.
Thanks a lot. I'll send you an email pertaining to my earlier question, and if anything else pops up, I'll add that.
Brilliant. Okay, everybody, have a lovely rest of the day, and I very much hope to see you again in September.